This is Michael Popok, Legal AF. When the judge in your civil fraud case says that your motion for mistrial to stop a 7-week civil fraud case trial in its tracks is, quote, utterly without merit, and therefore there needs to be no further briefing, he's ready to rule right now and deny the motion, you know it's a bad day for Donald Trump. That's what happened just today. Judge Engoron, in a 6-page order declining to sign Trump's proposed order to show cause, has denied as meritless, utterly meritless, to quote Judge Engoron, the motion for mistrial in which Donald Trump tried to throw over the game board and stop the 7-week trial already in progress in its tracks. This is the same Judge Engoron that was just sued yesterday by Donald Trump again in his official capacity as a trial judge with a lawsuit filed at the Court of Appeals, or the appellate court level, the First Department Appellate Division in New York level, because they don't like the gag order that Donald Trump is subject to, has violated twice, and there's 2 gag orders by Engoron. So they went running to the appellate court. The appellate court, you may have heard, for temporary basis only until full briefing, put a stay on the gag order. But they doubled down on the mistrial motion. They want to get rid of this judge because they don't like the judge, because they don't like the rulings the judge has made. The judge 7 weeks ago found persistent fraud in the operation of Donald Trump's business for the last 5 years and is just about, right? His finger is twitching, is just about to write a decision that's going to take away Donald Trump's building, property, houses, and money. And they don't like that. And so for good measure, they don't like the law clerk that sits next to the judge and helps the judge, assists the judge in keeping straight all of the evidence over a 10 or 15-week trial, the 40 or 50 witnesses, the terabyte of information, the evidence and documents that are presented. The judge needs help. There's no jury here. It's just a judge, just one lone man in a black robe. So occasionally he turns to his law clerk and asks her for some information. We don't know what they're discussing because it's confidential between the law clerk and the judge, as allowed under the judicial ethics and judicial canons of ethics in New York. But to outsiders who don't practice law in New York, like the lawyers for Donald Trump, oh my God, there's something terrible going on. Look, the law clerk sits next to the judge. Newsflash, the clerk or the deputy or the magistrate or whomever always sits next to the judge. Have you not been in a courtroom before, lawyers for Donald Trump? And if you don't know what I'm talking about, you haven't tried enough cases. And so they make a big deal out of that. They don't like the rulings. Oh, the judge is against us more than he's for us. That must mean he's biased. No, it must mean your case is crap. And there's a legion of case law in federal and state court that says bias is not because you don't like the judge's orders against you. In fact, you can't even usually use the things that happen in the courtroom as evidence of bias. And so the judge took one look at the motion for mistrial, and I did a hot take. We did a whole description of this on Legal AF on the MeidasTouch network, and said, let me see what the Attorney General has to say. And the Attorney General filed and said, give us full briefing, Judge. Don't even allow the motion for mistrial. Because procedurally, it was brought in under New York law under what we call an order to show cause. So you have an order to show cause, and you have the proposed order underneath it, and then you have a brief of supporting legal authority. It's a little bit unique in New York. You do everything sort of by an order to show cause, and then there's a briefing schedule, and the judge needs to sign it. But the judge today, as part of his order, declined to sign for the reasons stated in the order. You can see it right there with his little signature, AE, for Arthur Engoron. He refused to sign the order to show cause, to even set a briefing schedule, because he said in his order, we don't even need a briefing schedule. I don't need to hear more. We got the letter brief, which is the letter request to enter the order to show cause by Trump's side. We got the New York Attorney General's letter in opposition. I don't need briefs. Who needs briefs for a full record? And there, see, he did rule against the New York Attorney General, because the Attorney General said, let's do full briefing, Judge. It's better for the record. On page 5 of the order, the judge said plaintiff has advocated, that's the attorney general, for full briefing, emphasizing that although it believes defendant's motion is without merit, it is also a briefing would economize the timing and effects of any appeal. But the judge says, however, in good conscience, I can't sign a proposed order to show cause that is utterly without merit and upon which subsequent briefing would therefore be futile. Judge went on in a scathing order to basically shove back, not push back, against Donald Trump's lawyers. And here's how he summarized the attack on himself. He said on page 3 of 6, or the first page of the order declining, defendants' supporting papers argue a mistrial is necessary because essentially the court has exhibited bias. One, directly as I publish a high school alumni newspaper. Talk about grasping at straws here, with links to articles referencing the case. And two, indirectly through my principal law clerk, whom they allege has violated a rule of conduct in New York by exceeding the permissible amount of political donations in a calendar year. Judge went through each of those. He said, I have been doing the thankless job of editing the high school alumni newsletter. I've been doing it like for 40 years. I attach for everybody a link. Just because I'm linking articles doesn't mean I'm commenting on the case inappropriately under the ethics standard. And there's no rule that says I have to be lobotomized, this is my paraphrase, or to drop my personality from my cases that I'm presiding over. Let's remember, this is the same judge who, to start the case, took off his glasses, looked over at the camera, and smiled. Okay? He's allowed to be a human being. This is an elected judge position in New York. This is how it works. You know, he cracks jokes occasionally. When they called Ivanka Trump to the stand, he joked out loud, who's that? I mean, you know, he's a New Yorker. I think your judges should fit the character of your city. And if you want to be a character, you can be. And the judge said that as well in his order. Then the judge decided to also teach them, the lawyers for Donald Trump, stop submitting expert testimony that's nothing of the sort and is about legal issues. So they try to submit a former judge to try to teach this judge about the legal bases for mistrial. And the judge said on the top of page 4, or the bottom of page 3, as I explained in my September decision, and order granting partial summary judgment, legal arguments are for counsel to make and for judges to decide. Expert affidavits are neither permitted nor necessary. The rule prohibiting experts from providing their legal opinions or conclusions is so well established that it is often deemed a basic premise or an assumption of evidence law, a kind of axiomatic principle. The court has already cautioned, Judge Engoron went on, the defendant's counsel against submitting expert opinions on purely legal issues. Moreover, as detailed herein, the former judge's expert opinion incorrectly summarizes the relevant law and fails to address all applicable governing ethical guidelines. So not only was it improper to be submitted, and they've been chastised about this before, but it was I almost said a POS. It was not very good, the expert's submission, and it missed a lot of the analysis. For instance, the judge says, what you have missed is that my law clerk is running for office. She wants to be a judge. She's allowed to exceed the limits of $500 in donations because she's running, citing a judicial ethics opinion from 1998. And he said, my clerk has been running for judge since 2020. And therefore, that ethics opinion, which you get when you write a letter to the judicial governing body. Lawyers do this as well for their own conduct, and you get back an ethics opinion. If those bodies of ethical regulatory bodies want to guide other people's conduct, they publish them as ethics opinions, and you can cite to them to govern your actions. And clearly, the principal law clerk's conduct is consistent with this particular ethics opinion, which says that the $500 limitation on political donations does not apply when she's running for office, period. Then he went on to say, you also don't like how I interact with my law clerk, and which is also the subject of the gag order. And he said, you got the law wrong. right? The relationship, he quotes in footnote 2, the relationship between a judge and his or her law clerk is one of particular trust and confidence. Although a judge and his law clerk are, of course, not partners, the two engage in the kind of professional interchange that might be found between longtime colleagues in a law firm. I've had longtime colleagues in a law firm. I've been doing this for 30 years. And even at trial, I often lean over to my trial partner. We share notes, conversation, comments. They point out something I missed. I point out something they missed. They hand me an exhibit. They hand me a document. They point out the testimony is inconsistent. That's what the principal law clerk gets to do. That's what she's doing when she whispers in the court's ear or handing him notes. If he was more electronically savvy, she would be direct messaging him like in other courts. Oh ho, she's sitting next to him. Oh ho, she's the co-judge. The judge says, I don't even know what you're talking about. He says on the top of page 5, as I have made clear over the course of this trial, my rulings are mine and mine alone. There is absolutely no co-judging at play. That I may consult on the trial record, the law, and the facts before issuing any respective ruling is within my absolute discretion and is no way evidence that the final decisions are anyone's but mine. There is no factual or legal basis for a mistrial based on the allegations against my principal law clerk. And he went one step further. The judge said that accusation and series of accusations against the judge, for instance, that he's biased is in bad faith, meaning the judge could make a bar referral, a referral to the New York bar, or in this case, the First Department Appellate Division regulating lawyers that practice there, and send Keiss and Robert and Haba there because he has been accused in open court in bad faith of things that he didn't do or say. And here's the particular paragraph in his order on page 5. To the extent defendants argue that I have exhibited bias by stating in court that, quote, I'm not here to hear what Donald Trump has to say, such argument is disingenuous and made in bad faith, as defendants omitted what I said immediately after that sentence, which is, quote, I'm here to hear him answer questions. Indeed, those are precisely the roles of witnesses and the finder of fact, which he is. So that bad faith reference, although buried in this order, that would send a chill down my spine as an officer of the court, like these lawyers for Donald Trump. He could do a number of things. He could be like, all right, I'm fed up. The ones that aren't admitted to the bar here in New York and are here specially, I'm pulling their tickets. They can't practice in front of me in this case. And or I'm going to make a referral to the bar. And he could do that without threatening them, because you're not supposed to threaten that you're going to make a referral to the bar. You can make a referral to the bar about an ethical violation by a fellow lawyer as a judge or otherwise, but you can't threaten it. So it could just happen, and we'll have more reporting on that as it goes on. And then it was signed with the initials AE for Arthur Engoron, November 17th. That's where we have right now. We'll continue to follow what happens in all things civil fraud case. There's an actual case still going on. Nothing's been stayed, even though you'll hear that the gag order was stayed by the one judge of the appellate division, subject to full briefing and the appeal. The case rolls on and will go, it'll probably conclude right before Christmas at the rate that we're going. And the mistrial now has been denied. If they don't like it, they can go take it up with another panel of the appellate division and try to argue that the case should be stayed. I'm sure that's what they're going to try to do. The Trump lawyers will be like, oh, let's go right to the appellate court. We've already sued the judge. Let's sue him again and try to get the case off the tracks again. And we'll have to see. It's going to put the pressure on the appellate division First Department to say what is and what is not appropriate conduct and filings in New York. What kind of court are we running here? As a current officer of the court of New York and being a member of this particular First Department, that's a question I pose. That's what I posit. What is the court system that we are running here? And if this is sanctioned and if this is permitted and allowed, what does it mean for future cases in front of future Judge Engorons led by other outside lawyers who are practicing law by permission in our jurisdiction? I'll do hot takes like this one at the intersection of law, politics, and justice, but I only do it one place. The MeidasTouch YouTube channel. You knew that. Exclusively free subscribe. Where am I getting my words from? Help them get to 2 million free subscribers. And the bigger they get, the more your voice is heard, because there's no outside investors. It's a grassroots media company. Join me every Wednesday and Saturday for Legal AF, the curated podcast that we do at that same intersection, law, politics, and justice. We put together 5 of these stories or so at the intersection, and I do it on Wednesdays with Karen Freeman Agnifilo, former longtime prosecutor, civil rights lawyer extraordinaire Ben Meiselas on Saturdays, and then we do hot takes, the 3 of us, every hour, every day, all week long, and then we rinse and repeat and do it again the following week. Leave me a thumbs up for this hot take. It helps with the ratings, keeps the show on the air. Until my next hot take, until my next Legal AF, Michael Popok reporting.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.